Well, hello and good morning. Welcome to another Sunday morning coffee with Dr. Childress here. Today I'm going to be discussing the issue of justice having to do with the family courts and the fact that there's two litigants involved. Each litigant has a desire to identify what the problem is, and both litigants have rights in the family courts. So let's talk about that for a second. The first issue to understand about the legal system, it's an adversarial system, and both sides are equal in that system. The defense or prosecution, the plaintiff and the defendant. And so you got the two sides on this, but the two sides each have different desires relative to court orders and what's going on in the courts, because both parents are alleging the other parent is abusing the child in some way. Okay, so the allied parent and the child's symptoms are alleging that the targeted parent is abusing the child in some way because the child doesn't want to be with that parent, and they're saying, oh, there's malevolent treatment some way. Sometimes it goes up to the full allegation of abuse, and you got CPS involvement. Sometimes it's just implications of abuse, like psychological abuse, or not sensitive enough, or there was the unforgivable event that took place. A child was traumatized by something. And so you have the allied parent and the child's symptoms creating a narrative of abuse relative to the targeted parent. Well, that's of concern. That needs to be assessed. We got one of the litigants worried about child abuse by the targeted parent, or the symptoms themselves raise concerns about child abuse by the targeted parent. So that's one litigant, that's one concern. The other concern is from the targeted parent, the other litigant in this matter. And the targeted parent is alleging that the allied parent is psychologically abusing the child by creating a shared or induced persecutory delusion in the child. And that is that the allied parent has a major psychiatric disorder. So the targeted parent is alleging that the allied parent has a major psychiatric disorder, a delusional disorder, persecutory type, and that's being induced in the child, creating a false or factitious attachment pathology. And that's child psychological abuse. So that needs to be understood clearly here. Both parents are accusing the other one of child abuse. This is not a custody issue. Okay, it may be secondary custody issue, but the primary issue, when you have each parent accusing the other one of child abuse in some way, is to find out if there's child abuse in some way. And so what the court needs is a balanced information coming back from professional psychology about which parent is abusing the child. And if we have a child who's rejecting a parent, there's abuse by one parent or the other, because that's the only thing causing a child wanting to flee a parent. So we first think, is there child abuse by the targeted parent somehow, creating the authentic desire to flee that parent? If not, then it's a false or factitious attachment pathology, and we have the shared persecutory delusion of the allied parent that becomes a concern, one way or the other. And we have two litigants, each asking for their assessment for child. Now, what's happening in the courts right now is we're only getting the allied parent's assessment. We're not getting the targeted parent's assessment. And so they are being denied their rights in the legal system to present their case and protect their child. So each parent, we got two parents, justice, legal system, adversarial system, wants a different type of assessment. The allied parent wants a forensic custody evaluation because they want to focus on the custody decisions. They can manipulate the courts. So they want to get a custody evaluation that does not diagnose the pathology and advises the courts on custody rather than identifying the problem. The targeted parent wants a clinical diagnostic assessment for that persecutory delusion, for the major psychiatric disorder in the allied parent and the psychological child abuse. And because they want to focus on diagnosis and treatment. So each one of those litigants has rights in the legal system, and both of those issues need to be addressed because it's child abuse one way or the other, and the court needs to understand that information. Now, currently, this is the current structure in the family courts. Everyone else in psychology gets a diagnosis and treatment. That's ADHD, autism, depression, anxiety, eating disorders, substance abuse. Everybody else in psychology gets a diagnosis and treatment, except in the family courts. In the family courts, you guys get something called a forensic custody evaluation. It's an experiment in advising the court, a quasi-judicial role for doctors. And they do this experimental forensic custody evaluation thing that's really, really bad and doesn't diagnose, and it's just basically somebody's opinion. It's very expensive, takes a long time, it's harmful, it's really problematic. It represents financial exploitation of a vulnerable population. They provide no diagnosis, no solution, and it leads to destroyed lives. You're singled out in the family court. So I want you to understand this. As targeted parents, as one of the litigants in the court system, you are singled out to get inferior mental health services. Just you in the family courts get this forensic custody. Everybody else gets high quality clinical diagnosis, applied the DSM-5, and gets treatment to fix the problem. You don't get that. You get the financial exploitation of forensic custody evaluators. Here's the New York Blue Ribbon Commission, 4 years ago, 2022. By an 11-9 margin, the majority of commission members favor elimination of forensic custody evaluations entirely, arguing that these reports are biased and harmful to children, lack scientific or legal value. At worst, evaluations can be dangerous, particularly in situations of domestic violence and child abuse. I agree 100%. I review them. Okay, so yes, we should eliminate forensic custody evaluations entirely and go back to clinical diagnostic assessments. That's what the court needs. The court needs information on which parent's abusing the child and what to do about it, treatment. It doesn't need, doctors making decisions about custody. And I don't know, how they make those decisions on custody if they haven't identified what the problem is yet. We must first diagnose what the pathology is before we know how to treat it. We must first identify what the problem is before we know how to fix it. Diagnosis means identify, pathology means problem, treatment means fix it. So we must first identify what the problem is. And one parent saying, the allied parent saying the problem is a targeted parent is somehow abusing the child, and the child wants to flee that parent. The allied parent says the problem is a major psychiatric disorder, a delusional disorder in the allied parent, persecutory type, that they're then inducing in the child, psychological child abuse. So what's the problem? We need to identify what the problem is. Custody evaluations do not identify that problem. Diagnostic assessments identify the problem. And we want one parent wants a custody evaluation because they don't solve anything. The other wants a clinical diagnostic assessment because it will. So here's the differential diagnostic checklist. I got it up on my website. It's over in the attorney section, attorney resources. But you can just freeze frame it. This is just so simple. And you can take this differential diagnostic checklist and your attorney can give it to the court as a referral question. This is what one of the litigants wants. Answers to these questions from the psychological evaluation. They want to know is the targeted parent abusive? Okay, that's path A. So, is the targeted parent abusing the child in some way, thereby creating the child's authentic attachment pathology towards that parent? And if so, identify the type of child abuse, we'll put it on a treatment plan and fix it. Or, this is the targeted parent's concern, is the allied parent abusive? Is the allied parent psychologically abusing the child by creating a shared or induced persecutory delusion and false factitious attachment pathology in the child? So there it is, right there. We need answers to those questions, yes, no, from the psychologist. So we need to get a court order to answer those questions. And I don't care what the court order for the assessment says in general. One litigant, have your attorney, the targeted parent, have your attorney ask the court to get answers from the psychologist to this question. Is one parent abusive? Is the other parent abusive? If you want more specific on the allied parent, then there's specific questions to be answered that would be helpful. First, persecutory delusion shared. Does the allied parent have an encapsulated persecutory delusion? Encapsulated means it's limited scope. Encapsulated persecutory delusion regarding the targeted parent. And does the child share this persecutory belief? That's a persecutory belief is a fixed and false belief that the child is being malevolently treated in some way. If so, the diagnostic formal diagnosis is DSM 297.1, a delusional disorder persecutory type. So that's the first question we'd like answered about the allied parent. Second question we want answered is factitious attachment pathology. Does the child have a false or factitious attachment pathology imposed on the child by the pathogenic parenting of the allied parent? Pathogenic means pathology creating. So is the allied parent creating a false, factitious attachment pathology in the child? That's a DSM-5 diagnosis of 300.19, a factitious disorder imposed on another, FDIA. We would like an answer to that question. One of the litigants wants an answer to that question from the mental health people doing the assessment. Third question to ask, spousal psychological abuse. Is the allied parent using the child's induced pathology, that's the induced persecutory delusion and false factitious attachment pathology, as a weapon of spousal emotional and psychological abuse of the targeted parent? So we have now spousal abuse of the targeted parent by the allied parent using the child as a weapon. DSM-5 V995.82, spouse or partner abuse psychological. So we have child abuse diagnoses right up front, one parent or the other, possible psychological child abuse by the allied parent. Then we have the delusional thought disorder, we have the factitious disorder, we have the spousal abuse. Those questions need to be answered. We need to identify what the problem is. The targeted parent is saying, this is the problem. We need a mental health assessment to see if that's the problem. So right now, going back, everybody else gets the diagnosis and treatment, whereas you get the forensic custody. We need to change that so that you get a court order to get a diagnosis, because the court wants it, you want it, and that we need to identify what the problem is. You can get the other parent wants a custody evaluation. We can get that later. We can get that as part of it. I really don't care. Those are useless. Those are empty. They're very expensive. They're not going to solve anything. I'm focused on the targeted parent and what they are requesting from the court. So get your attorney to get a court order to get those questions answered as part of any mental health assessment. And so by the court order, you are then getting yourself diagnosis and treatment, because that's a solution. The mental health people right now are failing you. The forensic custody evaluators are failing you and the court by not doing this, by just not bringing it, by not giving it to you and so get a court order to get them to do that. That's called the referral question. So when it comes in for an assessment, is the referral question about ADHD? Is the referral question about a learning disability? Is the question about depression? What's the referral question we're assessing for? That's the guides all assessment. Do we worried about autism? Then the autism is the referral question. In this case, the referral question is whether the allied parent has a persecutory thought disorder. Please answer that question, and that can be part of the court order for the assessment. The court is fine on custody. They want to know about child abuse, and so you can have your attorney include those questions as part of the court order. Please answer those questions. And now we get an assessment from the mental health people. Now, if they having problems and don't know how to do it, the mental health people, I've got videos up on YouTube. They can go watch the videos on diagnosing attachment pathology, diagnosing delusional thought disorders, diagnosing child abuse in the family courts, and the DSM-5 diagnosis. I also have booklets on the assessing, the 50-page booklet on assessing attachment-related pathology in divorce, and for treatment, I've got a contingent visitation schedule. So they can go read those. They can go get those. And if they want, they can grab my book. Yeah, I don't have it sitting around. But I've got a book on this, Foundations. You can give them the book if they want to read up and learn. It's a 10-year-old book. They should have read it already. But if they don't know how to do it, there's plenty of resources where they can learn how to do it. And if they don't know how to assess for the delusional thought disorder, they shouldn't be working in the family courts. Okay, simple enough. Now, outcome measures. All treatment should have an outcome measure to it. How do we know if it's working? And so that's our goal. Our goal is an improvement in the outcome measure. And this is standard. But goals need to be specified in measurable ways. You can Google WikiHow treatment plans, goals and measurable ways. We need an outcome measure. So the outcome measure that I recommend for the family courts are daily ratings made by the targeted parent on a 7-point Likert scale. That's the type of scale is 1 to 7 or 1 to 10. That's called the Likert scale. A targeted parent on a 7-point Likert scale for 3 relationship features: affection, that's your attachment networks; cooperation, emotional regulation networks; and social involvement, that's mood and arousal. So we just get daily ratings from the targeted parent when the child's with them on those 3 items, 1 to 7, and you email those to the treating family therapist. And then during the family therapy, you talk about the ratings and why and what happened and what's normal and how to resolve it. So 1 or 2, ratings of 1 or 2 are considered problematic. Those are symptomatic. Okay. Anything 3 or higher is normal range. So we don't need 6s or 7s. We just need normal range, 3 or higher. Now, even if it drops to 1s and 2s occasionally, that's fine. That's kind of normal. We just don't want to see it staying there. We want it to be normal range, which is mostly up in the 3s and 4s. And this becomes part of the contingent visitation schedule as well. But this should be done all the time. All the time. Am I clear? All the time. So immediately when you get treatment in for one of these child rejecting a parent, start getting ratings from the targeted parent about what the relationship's like, because our goal will be to get the child in normal range. Okay, so that's our treatment goal, 3 or higher on everything, and then we identify what the problem is, what's the barriers to treatment, what's going on, which parent's causing the problem, and we fix it, because that's our goal. And that achieving that goal is mandatory. Okay, we got to restore to this child a normal and healthy life. Treatment failure is not acceptable, especially in child abuse. Okay, we need to protect the child. We need to fix the child. We need to give the child a normal range life. And so if the allied parents is abusing the child, we need to fix that and restore the relationship. If the targeted parent is abusing the child, then we need to fix that and restore the relationship. But we need to get the child a normal range life. And that's like non-negotiable from the psychology people, or should be. So what about the family courts then? Well, what I recommend for the family courts, it's an adversarial system. Any diagnosis returned into the family courts will be a disputed diagnosis. That's just a fact. One parent or the other is going to dispute the diagnosis. The appellate system in healthcare for a disputed diagnosis is second opinion. So rather than get an assessment, then a second opinion, then everybody starts to fight about it, and then you get a third opinion. Everybody's fighting about it. Get the second opinions right up front. That's what healthcare does all the time. You go in and say, doctor, this hurts. He says, let's get an orthopedic consult. Boom, immediately. Because we need an accurate diagnosis to begin treatment. So you pull your second opinions right up front. And then you allow the court to look at the reports coming back, the opinions of the doctors, and then the court can make its decisions moving forward. So what I recommend, because it's a legal system, we got two litigants. Each litigant is accusing the other of child abuse in some way. Litigant 1 is child abuse by the targeted parent. Litigant 2 is child abuse by the allied parent. Allow each litigant parent to appoint a second opinion of their choice to participate in the clinical diagnostic assessment through telehealth, to then get those reports into the court for its decision making and then lead into the treatment plan. Okay, easy peasy. And if you get the 3 doctors' reports coming into the court is fully capable of making its decisions about what's going on. We also have something called response to intervention. So, we can look and we can get a diagnostic formulation for things, but then we can put it into treatment for one or the other possibilities. And if it works, that's the problem. If it doesn't work, that's not the problem. And so we have various options we can do off of that. But let's first get the court appropriate information. Now, the reason we do second opinion in healthcare and consultation is because it improves the quality of healthcare services delivered to patients. So if your primary care physician is just guessing as to what the problem is, they're going to mistreat the problem. But if they send it out for a consult, a specialist consult, they get an accurate diagnosis, they can get a fix on it. So it improves the quality. Now, I guarantee you, if you get each litigant parent appointing a second opinion to that, that's going to upgrade the type of assessment and the quality of information coming back. And if you get the low quality of information from any one of those doctors and the other 2 are giving good quality information, the court's going to recognize which ones doesn't fit with the others. And diagnosis is relatively simple. You got the symptoms and you got the diagnostic criteria. You apply the diagnostic criteria to the symptoms. If there's a match, that's the diagnosis. If there's not, it's not. And so the court can look at the diagnostic criteria, it can look at the symptoms, it can say, yeah, those match up. But let the doctors collect the symptoms, apply the diagnosis, and tell the court what's going on, and the court can then make its decisions going forward. It will improve the quality. Now, this model, well, look at me, old guy. I'm turning 72 this year. I'm out of here. This model will stay after me. That this isn't a model that works because it's healthcare. You get a doctor to do the diagnosis, you get the second opinion consultants, and everybody can switch around in doing that, and will improve the quality of healthcare services delivered to the parents in the court, delivered to the children in the court, and delivered to the courts. That's what it does. Consultation improves the quality of healthcare services. So let's get high quality information to the court system. So the key issue for this, though, is the clinical diagnostic assessment. We need to get one of those, please. And then, if somebody wants to appoint me as a second opinion, I'm going to be improving the quality of that. And the opposing party can appoint their second opinion consultant on that. We can all do our assessment, participate in telehealth and stuff. We got it now. Yay, the internet. And so we can absolutely do. We just need a clinical diagnostic assessment. So get the court to order a clinical diagnostic assessment, both people. Now, you get the court order for the forensic custody evaluator to do a diagnostic assessment. Now, here's the problem. The forensic custody evaluators are withholding clinical diagnostic assessments. They're only offering their custody evaluations in order to exploit the families for money. And they're not solving anything, and it's their nice little cushy career of getting $20,000 to $40,000 per assessment. They don't have to know anything or solve anything, or they get to do it. It's awful, awful system. But they are the ones working in the family courts, so they are the ones with the obligation to meet the needs of the court and the litigants. The borderline therapist who's working out in the community with the dialectic behavior, they're not working in the family courts. It's not their obligation to meet the needs of the court. The spousal abuse therapist working with, general physical spousal abuse or things like that is not working in the family courts. It's not their obligation to meet the needs of the court and the litigants. It's the forensic psychologists who are working in the family courts. That's their obligation to meet the needs of the court and the litigant parents, not their own needs, okay, to get a cushy job and I want to do custody evaluations. Very interesting. The court needs a clinical diagnostic assessment, the litigant parent needs a clinical diagnostic assessment, and you're in the family courts. So it's up to you to meet the needs of the court. So that's where you get the court order for the diagnostic questions to be answered as part of the referral over to the forensic custody evaluation people. They got lists on the court. You can pick them off the list and say, got 3 of them. Here's your referral question. Now, they can still do more than that. If they want to advise the court on custody, they can do that. But they at least need to answer the court's questions about which parent's abusing the child. Is there a persecutory delusion present? And if they can't do that, then they should not be working in the family courts, because that's what the courts need. Okay? If you're not competent to assess for a delusional thought disorder in the allied parent, you are not competent to be working in the family courts. So when you get a referral that's from the court asking whether or not there's a delusional thought disorder, and you're working in the family courts, you got your name on that little court list, it's your obligation to answer that question, or else you're saying, I'm not competent to answer that question. Then you need to be off the list. There it is. But now we got some conflict of interest issues going on here. So there it is. That's what we need answered. The question's really simple. Yes, no. Yes, no. How much more simple is it? And we need that specific question. Is the allied parent abusive? Is the allied parent psychologically abusing the child by creating a shared induced persecutory delusion and false factitious attachment pathology in the child? Put that in your court order and ask the psychologist to assess for it. If they can't assess for it, they're not competent to be working in the family courts. But they can go watch the video. I got YouTubes on it. I got booklets on it. They just need to learn how to do it if they want to work in the family courts, because that's what we need. The situation we have right now is called institutional betrayal. That's Freud's work, Smith and Freud, 2014, Institutional Betrayal in the American Psychologist, the flagship journal of the APA. That is exactly what we got. We've got regulatory capture and institutional betrayal. Now, Freud adds another word to that, institutional betrayal trauma. And so all of the parents and all of the children who've been in the family courts from getting custody evaluations that are dangerous, harmful to children, lack scientific and legal value, result in potentially disastrous consequences for parents and children. All those children and parents from the last 40 years have endured and are enduring institutional betrayal trauma. Oh my goodness. And there's traumatic grief in the targeted parents. We're in trauma world. We're in spousal abuse and child abuse. We have institutional betrayal trauma. We have regulatory capture, and we have the traumatic grief, trauma. Okay, we need to get on this and get proper diagnosis and get effective treatment for the trauma, for the child abuse, for the spousal abuse in the family courts. And this whole custody stuff needs to stop. But the moment it stops, all these people are custody evaluators are out of a job. The moment you give them the referral question that says, please assess for delusional thought disorder, and they say, well, I don't do that, then they're out of a job. They need to be out of the family courts and so go work with ADHD or something. And they don't want to do that. So they are going to work against providing a diagnosis of the child abuse. They are covering up the child abuse for their own financial benefit. Because if they start diagnosing the child abuse, we don't need their custody evaluations. We need a clinical diagnostic assessment. We don't need 6 to 9 months of their made up stuff. We need 4 to 6 weeks of a diagnostic assessment applying the DSM-5, and they cease to exist as an entity, forensic custody. And so there's a major conflict of interest right now. So the litigant parents want a litigant parent, the targeted parent, wants a diagnostic assessment of the allied parent and child. The court wants a diagnostic assessment of the allied parent and child. It is the responsibility of the psychologists who work in the family courts, the forensic psychologists, to meet the needs of the litigant parents and the courts. Are we clear? Okay, they're not working the family courts to meet their needs. Well, yes, they are at this point. But in truth, you're working for the client. The client is the court. The court is asking you to do a diagnostic assessment. If you can't do that, then you need to get out of the courts because that's what the court needs and is asking for. So you need to learn what you're doing if you're going to work in the family courts. This is child abuse. This is spousal abuse. So I want to be very clear about the world. It's not euphemisms about parent-child contact problems or resist, refuse, or parental alienation. No, stop using euphemisms. The targeted parent is asking for an assessment for child abuse and spousal abuse, psychological child abuse and psychological spousal abuse. You need, as a psychologist, to do that. So get the court orders to do that. That's the job of your attorney, to get those court orders. And then you get your list of people in the family courts and you run down and say, here's my court order. I need a diagnostic assessment of the delusional thought disorder. The concern is psychological child abuse by the allied parent. The concern is spousal abuse of the targeted parent by the allied parent using the child as the weapon. In a couple of weeks, March 9th to 12th, and then March 16 to 18, 2026, AFCC is having an online training program. That's a significant program, okay, that we're talking 28 hours or something like that they're advertising for the fundamentals of conducting parenting plan evaluations. And there's your training team. Now, the first person there on that is on the board of directors of the AFCC. I know that already, and I'm starting to get familiar with who the rest of them will be going forward. But those are the people right there, that instructor list. those are the ones that should be providing the diagnostic assessments to the court. Okay, and they should be competent to do that. And these parenting plan evaluations need to be entirely eliminated from the family courts because they are dangerous, harmful to children, lack scientific legal value, produce defective reports that with potentially disastrous consequences for parents and children. New York Blue Ribbon Commission. So what they're talking about should be entirely eliminated. Now, one of the things I'm attending this course. It'll be very interesting. Now that first week, that's the first week of the month, though I'm also seeing clients, so I'm going to have to kind of watch it in between my clients a little bit, but then I'll watch it in the evening. I'll go through it all and catch up. The final two days I'm available, and I'll be watching it, and then I can have the transcripts and slide decks and whatever they do off of this. So I'm going to be very interested to see what they say are the fundamentals of an experimental approach. Okay, a quasi-judicial role for doctors is an experimental role. The traditional role for doctors is diagnosis and treatment, not parenting plan advising the court on custody decisions. That's the court's decision, it's not a doctor's decision. In the absence of child abuse, parents have the right to parent their child according to their cultural values, their personal values, and their religious values. In the absence of child abuse, each parent should have as much time and involvement with the child as possible. In the absence of child abuse, to restrict either parent's time or involvement with the child would damage the child's attachment bond to that parent, thereby harming the child and harming the parent. So from a clinical psychology, doctor perspective, the question is whether there is child abuse. If there's no child abuse, then parents have the right to parent. Each parent should have as much time as possible, and there's no reason to restrict the child's time. It now becomes a court's decision about various factors that the courts want to worry about, but there's no child abuse involved, so the court can decide on situations. Now, if there's child abuse, then we protect the child, and everybody needs to know that. Is there child abuse by the targeted parent, resulting in a true child rejection, authentic rejection, or is there child abuse by the lied parent, the psychological abuse, the delusional thought disorder, in which case we need to protect the child from that parent? Okay, that's what we need. We don't need a parenting plan. So it'll be interesting for me to watch this. Now, I just want to also point out, you parents, anybody, your attorneys, everybody can watch this as well as me. And so now, if you parents were organized, imagine if 10,000 parents sign up for that. Oh my God, they'll make a lot of money, but holy cow, you get a lot of oversight. Okay. Imagine if you get state legislator representatives doing that, but that's 28 hours, and they're not going to want to do that. So nobody is going to watch this going forward because you're not really organized in what you do. I'm a couple of advocates. I suggest you watch this and download the transcripts, because this potentially is part of the class action lawsuit going forward, that they're giving you inferior services going forward. We'll see what happens. For me, personally, I'm going to be most interested in the informed consent aspect of this. Do they talk about alternatives to these things that the courts are informed? You have an alternative of a clinical diagnostic assessment, and talked about the risks and benefits of a custody evaluation of these parenting plan assessments versus the clinical diagnostic assessments and that sort of thing. Do they inform the courts and the parents that these lack scientific and legal value, that there's no inter-rater reliability, and that the New York Blue Ribbon Commission found them to be harmful to children and dangerous? Do they inform the courts and parents about this, or are they withholding information? Are they offering alternatives of community care as usual, diagnostic assessment, or are they providing only their experimental approach. And then we have all sorts of issues about IRB approval and risk-benefit analysis, protection for vulnerable population, things like that. So I'm going to be very interested in this upcoming training here. I'm going to wrap up on my Sunday here. We're at a phase now where we need to solve this. Okay, I've been telling people, I've been working, getting the information in there, but we have a situation of institutional capture. I know that. So I've documented the AFCC in 2017. I went to their convention and gave them a bunch of slides, that's up in an exhibit where I said they're not competent in doing assessing the pathology, attachment, delusional thought disorders, family systems, and complex trauma, personality disorders. They're not competent in assessing it. Then last year, I took a course from 8 prominent forensic custody evaluators. Same thing. I look and said, you're not competent. I sent them a letter, 1.04, my mandatory obligations for informal resolution. They sent me back a response, wasn't appropriately handled in that way. You can look at those. Those are exhibits on record now of my one letter to them and their response. And then I notified the APA Ethics Committee. They said, no, we don't do this until you file a board complaint. We don't review psychologists. And I notified the board of directors. Now I notified that Aoki, the top one listed for this course, I sent a letter to her notifying her of all the concerns relative to last year's one. These are none of those custody evaluators. There's a whole new set. And we got board of directors of AFCC members on. So we have an institutional statement about custody evaluations, forensic custody evaluations, what they call parenting plan evaluations. So they're on record now. I'm just going to sit back and get the record, and we'll see what happens off of this. But what you can do in the family courts is get your attorneys to get those questions answered. Your attorneys are working for you, and you want to protect your child. You need the diagnosis, so that's up to the attorney to get the diagnosis. Who should do the assessment? Well, the forensic custody, all those people on the list. When they say no, 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 then they're not meeting the needs of the court or the litigants, and they're not competent to be working in the pathology. They need to go away and get their names off the list. And then we're going to deal with the reality that we don't have mental health services in the family courts, and then we'll kind of cobble stuff together with the help of the court. And potentially, once you get these orders coming out of the court, the forensic custody evaluators will switch teams and go back to clinical psychology and start diagnosing the pathology. All they have to do is watch a YouTube video and read the DSM and start reading books on like attachment, and get competent in what they're doing. And boom, they're right back in the family courts, meeting the needs of the court and the targeted parents and the children, protecting children from child abuse. So with that, I'm off to my Sunday here. Good luck, everybody, and take care.